Hello, everyone, and welcome to another live edition of Employment Law Q&A. Good morning or afternoon to those of you just tuning in. My name is Alex Lucifero. I'm an employment lawyer partner with Samfiru Tumarkin LLP. We are the employment lawyers, and this is another live stream. We obviously do these on a very regular basis, although myself, it's been quite some time since I've done one of these live streams. Very happy to be back. Very happy to be back answering any and all questions, really. If you're just tuning in now and you're dealing with a situation at work, whatever the situation is, maybe you're being mistreated by a manager or by a colleague, maybe you've been laid off from your employment temporarily, maybe there are changes happening at work, maybe you've been let go from your job and you're being offered some sort of severance, or maybe the company is making some nasty allegations against you and terminating your employment. Really, whatever the issue is, you need to speak with an employment lawyer if you're dealing with a problem at work, even if you're dealing with a difficult work situation. And that is what we're here to do right here, right now, live. Whatever platform you're viewing this on or hearing this on, please go ahead and post your question right now. It could be completely confidential. You do not have to mention your employer's name or your personal name or any particular details. Feel free to ask the question in a very general, very generic way, and I promise before the half an hour is up, I will get to your question and get you on the path, get you moving in the right direction in order to solve that workplace problem. These workplace situations, again, whatever the scenario at work, they're not worth losing sleep over. They're not worth stressing over. Of course, any kind of stress, certainly workplace stress, we see it every single day, leads to health issues, leads to a lack of sleep, leads to mental health issues. You want to nip these problems in the bud. You do not want them to fester. You do not want them to linger really at all. And again, the path and the first step on the path in order to start solving that problem is by speaking with a professional. In the context of a workplace situation, in the context of a workplace problem, that professional is an employment lawyer, and this is the bread and butter of our work. It's what we do all day, every day. Actually, to get the ball rolling here, and as the questions start rolling in, and please, everyone, go ahead and post your questions right now. We'll get a few lined up as we start the show. As usual, a couple of things I want to get out of the way here. First is our contact information. You see a website on the screen right now. It's employmentlawyer.ca. That is our website. Go ahead and visit us there. And it's a great starting point, really, because we've got a ton of resources online. We've got articles, videos, posts. I mean, you name it. If you need a place to start trying to square up and figure out your workplace problem, go ahead and visit our website. Have a look through the articles. Have a look through the kind of the essential posts that we have on there. And it will stand out to you. Your particular problem will likely be dealt with a brief article. Of course, we've got our contact information on our website as well. If you want to email us, our email address is on the screen right now as well. help@employmentlawyer.ca. Very straightforward, very easy. help@employmentlawyer.ca. Go ahead and send us an email. Do not be shy. It is strictly confidential. We are not allowed. As lawyers, we cannot disclose your information to anyone. So what you send us is strictly confidential. Go ahead and give us a brief description of your problem. Let us know that you've been let go if you've been let go from your job. Let us know if you're dealing with bullying or harassment in the workplace. Whatever the issue is, go ahead and give us a brief summary. And I promise, I guarantee it, someone will contact you back. We have an entire intake team standing by, just waiting for those emails, waiting for those phone calls. Of course, you can give us a call at or any one of our offices if you'd like as well. We practice employment law in Ontario, British Columbia, and Alberta. Those are the three provinces in Canada that we practice in. If you're in one of those provinces, you're in luck. Don't be shy to give us a call or send us an email. The number's on the screen right now, actually, so feel free to jot it down. If you're in another Canadian province, or if you're in the United States and watching this, listen, unfortunately, we will not be able to assist you, but that's okay. You've got employment lawyers in your province or in your state that you can likely reach out to. And even if you want to post a question yourself, go ahead and post it, and we could give you a general sense of the way the law works in these particular scenarios. But you do want to speak to somebody in your jurisdiction, in your province, or certainly in your state if you're in the United States. Thank you so much for those of you just tuning in and starting to post some questions. I see a couple of lined up already. Ron, MS, Sam, thank you so much for asking. I promise I will get to your questions and I will answer them. For those of you just tuning in right now and a little late, my name is Alex Lucifero, employment lawyer, partner at Samfiru Tumarkin, LLP, and this is a live Q&A. So if you're dealing with a problem at work, maybe you're dealing with a medical leave of absence. Maybe you're dealing with disability insurance and group benefits insurance, and you have a question about your medical leave or you have a question about disability benefits. Well, listen, guess what? We practice disability law as well. And if you're dealing with that kind of situation and tuning in, again, do not be shy. Do not be bashful. I guarantee it, there are no bad questions when it comes to employment law or disability insurance law. Any question that you're wondering about, I guarantee you there are probably dozens and dozens, if not hundreds, of others out there dealing with the exact same workplace problem, dealing with the exact same question, and wanting to know what the answer is. So listen, obviously you're helping yourself. If you post your question right now and get it answered, again, you're going to be getting on the way to resolving that workplace problem. But I guarantee you, by asking that question, you're also helping a heck of a lot of other people out there who are looking for that guidance, looking for that help, and maybe they're too shy to post the question or ask a question. So again, do not be shy. Feel free to ask your question, and you'll be helping yourself and others as well. Okay, very quickly, guys, because I do want to get to the question. I do want to run through what we call the case of the day as part of our radio show that we host on a daily basis, Monday to Friday, in Toronto at least. We do a little segment at the start of that show, always called the case of the day. It's an opportunity to talk about a matter that came across my desk in this case, and hopefully provides a bit of a lesson, a bit of guidance to our listeners, but also today to our viewers. And this is a case of the day, if we can call it that quite frankly, we see lots. And we're seeing more and more of nowadays as the economy stutters and slows down, as employers start to tighten their belts and even restructure their operations. This is a scenario that we see now time and time again. And I think it's going to be a good lesson for those of you just tuning in. Now, spoke to a gentleman earlier this week, very nice fellow in his 50s, pretty long service with the same employer. I think he was with the company for about 13 years, give or take. And he's a sales employee. And this is particularly the case and a case of the day that might be geared more towards employees that have a bonus or a commission or what they call incentive pay structure to their compensation package. So these employees typically will earn some sort of base salary. Sometimes that base salary is even relatively modest. It's not a huge base salary as a starting point. But particularly sales employees, there might be huge incentives there for commissions or for bonuses or again for incentive pay, and that might bring their total compensation to a potentially very high number. And salespeople, of course, well, they rely on sales, right? They rely on those commissions, they rely on those bonuses to make up the majority of their salary. And this was exactly this gentleman's case. He earned a very small, relatively small base salary, but he was a very good salesperson. Doing this kind of work. So for 13 years, lots of experience selling these particular products in this particular industry and doing very well for himself. Lo and behold, earlier this year, and this is the time of year that these things tend to happen, we're talking spring here, the employer introduced a new sales plan for the year and a new commission structure for the year. And all along for the past 12 or 13 years, this employee has been more or less on the same plan, give or take maybe a percentage point or two, but he's been earning effectively the same thing for all this time, depending on his earnings, depending on how much he did or didn't earn. But that was entirely within his control and the market's control. His employer never really adjusted the commission percentages all that much until this year. When this individual saw the company's new sales plan this year, he was actually quite shocked that the commission percentages that he was going to be earning on new sales was drastically reduced. It was reduced something to the tune of kind of 20 to 30%. And that was going to take a huge chunk out of his commissions. And the commissions being the majority of what his earnings were for the entire year, that was going to have a really big impact on his total compensation, on his overall employment income with the company, and it was likely going to be to the tune of about 20%. In other words, if he was going to do the same sales as last year, which he was expecting to do, he told me at least, right? Despite working the same amount, despite doing the same amount of sales, because of the company's new commission structure, he was going to end up earning 20% less than what he was earning last year. So just to use a very, very easy example that I'm sure we'll all understand, if he earned $100,000 of base salary and commissions last year, having done the same amount of work this year, he'll only end up with 80. Right? That's a big change to his commission structure. That's a big change to his employment. And what I really want to emphasize here, and the lesson here for everyone, and you don't have to necessarily be a commission salesperson. You can be supervisor, you can be a general laborer or an administrative worker, or you can be a manager for that matter. If your employer makes a change to your pay or makes a change to your bonus that is going to cause you to have to or be forced to accept a significant reduction in your total pay from the company, that is what we call a constructive dismissal. A constructive dismissal is a fancy enough way of saying that could be a breach of contract. Your employer at law is actually not allowed to make that kind of drastic change to your pay or to the terms of your employment more generally without your consent. So, of course, in this gentleman's case, listen, if he agrees to the new sales plan, if he signs off on it and accepts it, well, I hate to say it, but that employee is out of luck. So if your employer is asking you to make a major change to your employment, maybe they're demoting you, maybe they're asking you to take a temporary layoff. Listen, if you accept that change, and there might be reasons to do so, probably not many, or it might be better to consider it a breach of contract. But if you accept those changes, well, you've accepted them, right? And that's a deal, however unfair it might be. My point here is you don't have to accept those changes as an employee. And this is the starting point really for lots of employment situations. You should know as an employee what your rights are in any given situation. What options do I have? Do I have the right to say no? Do I have the right to say, no, I'm sorry, I'm not agreeing to that change to my sales plan, right? I want my sales plan to stay the same. I'm not accepting a $20,000 pay cut or whatever the number is, right? If it's a significant reduction, and obviously a 20% change to your pay is going to be considered significant without a doubt, you as an employee have the right to say no. The employer then has a couple of options. They can either back down, and hopefully in this gentleman's case, they do back down and allow him to continue earning what he was currently earning, and we're working on that with him behind the scenes to make that happen. But as an alternative, the employer really isn't going to play ball, right? And they're going to insist on this change. By far, your best option as an employee is likely going to be to consider yourself constructively dismissed, constructively terminated. In other words, consider that change from your employer a breach of contract. Consider your employment at an end, receive your severance entitlements, and get moving on to new employment. That is something that we as employment lawyers very routinely will help employees with because this is not a situation that in the long term is going to bear fruit. I'll give you an easy example here. Temporary layoffs. A temporary layoff, like a major change to your position or like a major change to your pay, is going to be considered a constructive dismissal. If your employer temporarily lays you off and you've never been laid off before and you don't have any kind of employment contract that allows the company to temporarily lay you off, you can treat that temporary layoff as a permanent termination. And that is by far the better option in those situations, because once you accept one temporary layoff, well, guess what? It now becomes a term of your employment that you've accepted, and the employer can then, maybe a few months from now, lay you off again, and lay you off again, and lay you off again next year, and it becomes a term of your employment. The same thing, by the way, with a position change or a pay change. If you accept that kind of change once, it becomes much, much more difficult, if not impossible, really, to accept that change a second time, or to to refuse that change a second time or a third time or a fourth time. So you don't want to get stuck in this pattern with your employer where they've asked you to make a change, you've accepted, and then they ask you to make it again and you've accepted, this becomes, again, a kind of implied term of your employment. It is much, much better, and we see it again every single day, to refuse that change at first instance, right? And if the employer doesn't back down, you know what? This is not going to work out. You're going to be owed severance as an employee. In this gentleman's case, as a 13-year sales employee who's in his 50s, he's looking at probably something like 14 months of pay as his severance entitlements, not weeks, to be clear, months of pay, right? That's significant, and that's going to allow him time to go out there and find another job that's going to treat him properly and pay him commissions and bonuses for his sales properly. So the lesson here is, if your employer is making any kind of change to the terms of your employment, do not feel forced to accept that change on the spot. If it's a minor change and maybe they're asking you to, change your shift by half an hour or maybe even by an hour, listen, minor changes, there's got to be some degree of flexibility and a conversation that could be had there about minor changes. But any change that you as an employee feel is significant, feel like it's a really big ask by the employer and really is going to kind of change your employment in a pretty significant way, do not feel pressured to say yes. You certainly don't have to say yes on the spot. My advice would be, tell your employer that you're going to think about it and get back to them. And then the first thing you need to do after that is get on the phone to our office, speak with an employment lawyer, figure out what your rights are, what your obligations are as an employee, what best option you have in the circumstances. Again, an employer is not allowed to force a major change on you. You have rights, you have options. One option would be to, force the employer to back down, and the other would be to seek severance. Before you resign your employment, before you really talk about, you talk to your employer about a constructive dismissal potentially, do email us at help@employmentlawyer.ca. Do speak with one of our employment lawyers. Again, we can point you in the right direction and guide you through that process. The good news is the law isn't all that complicated in these situations. We'll likely be able to advise you very clearly on whether or not you're dealing with a constructive dismissal, and again, what your best options are in the circumstances. Okay, that's enough for me, guys. I think I've gone on long enough here with my case of the day. Hopefully, for a few of you, it helped out and it pointed you in the right direction if you're dealing with changes at work. But let's get to the meat and bones of our live stream today, the questions from you. And again, if you're just tuning in, I am an employment lawyer and partner with Samfiru, Tumarkin LLP. This is our employment law and disability law as well, Q&A, question and answer session. If you're just tuning in midway, go ahead and post your question right now. If you're dealing with a situation at work, with a problem at work, and you want to know just where to start, really just what direction you should be headed in here, go ahead and post your question right now. Keep it short, keep it anonymous, but I promise I will get to it before the end of the stream. And with that said, let's get into it. Thank you all for your patience, those of you that have posted questions. I've got a good few lined up here, so let's get rocking and rolling. First up, Ron. Ron, thank you for your question and for tuning in today. Ron asks, can an employer fire you and not give you your severance at the same time? Well, a couple of points here, Ron. So number one, severance doesn't have to be paid the day that you're let go. Ultimately, an employer does have some time to pay out a severance payment. That time, at least in Ontario, Ron, is going to be either the company's next payroll date or 7 days from the date of the termination. And that's when a record of employment needs to be filed and provided to the employee as well. The reality, Ron, is that an employer will oftentimes offer an employee an amount of severance that doesn't reflect what that employee is actually owed. Oftentimes, we do see severance packages that are far less, actually, than what an employee's severance entitlements actually are. So, Ron, it's very possible that your employer lets you go. They offer you an amount of severance, and maybe they even pay you an amount of severance, but it's likely that you are owed significantly more than what the company has offered or what they even have paid, even if you have to wait a week or two for that payment. So regardless of the timing of the severance payment, regardless of what they have offered you, and really regardless of the circumstances of the termination, in other words, why they terminated your employment or not, listen, as soon as you can, again, give us a call, send us an email, share the details of the situation, right? We need to know your age, your length of employment, your position with the company, and with that information, we'll be able to give you a sense of what your severance entitlements are. We may even want to review any kind of employment contract that you might have signed with the company. And I guarantee you, whether it's a week from the termination date or a month from that termination date, we'll be able to give you a sense of what your termination entitlements are and what you're owed, and compare that to what the company has offered or paid you. Don't worry too much about the timing of payment. It's more the actual substance of the issue in terms of what they've paid. Great question to start the show off, though, Ron. Thanks for that. Next up, MS asks, I recently found out that my employer has misled me about overtime. I'm a salaried worker who regularly puts in several hours of overtime each week. My manager knows this and told me I was not eligible for overtime pay. Is there anything I could do about this now? Yeah, there was a follow-up by MS, but it's the same question. So MS, great question. Very clearly, doesn't really matter whether you're a salaried employee or an hourly rate employee or how exactly you're paid. If you are not a manager, right? Managers, if you're doing managerial work, are actually excluded from overtime pay. And that applies, of course, to anything more senior than managers, directors, VPs, et cetera. Listen, if you're a manager or an executive level employee of a company, you're not going to be owed overtime. It's your salary, and that's all it is. But if you're not a managerial employee, and again, it doesn't matter whether you're salaried or not, if you're working overtime in Ontario, again, at least in Ontario, that means more than 44 hours a week. Guess what, MS? You are owed overtime pay. Doesn't really matter what your manager says. Doesn't really matter what the context is, right? You are going to be owed overtime pay. Now, the good news in a situation like this is that for issues like overtime pay, vacation pay, wages, items like that, a great tool in Ontario that you can use for those kinds of issues is the Ministry of Labor. The Ministry of Labor in Ontario is the entity, is the government body that enforces those kind of minimum rules, right? So again, minimum wage is another one of those minimum, really, employment rights and standards, as we call them, that the Ministry of Labor can enforce. Now, to be very clear for those of you out there, if you're dealing with changes to your employment, a temporary layoff, or certainly a termination or severance issue, I want to be very, very clear in this. Do not go to the Ministry of Labor with those kinds of issues, particularly a severance claim, and particularly any kind of change that you're experiencing to your terms of employment. The Ministry of Labor cannot help you, or at the very least, they can only help you to a certain degree. You do not want to go to the Ministry of Labor when it comes to a severance claim. You need to speak with an employment lawyer. So MS, if this is strictly an overtime issue, you know what? If you can't sort it out with your employer, contact the Ministry of Labor. They will likely be able to help. If you've been let go from your job or you're dealing with other issues at work beyond overtime pay, guess what? Give us a call. Let's have a chat off air, right? We'll be able to figure out those other issues. But certainly, I don't care whether you're salaried or not. If you're working more than 44 hours a week, you are going to be owed overtime pay unless you are a manager. All right, next up is Sam. Sam asks, Sir, can you define the relations, purview, and provenance in the context of a workplace and kicking off the hiring process after initial employment outreach? Sam, that's a word salad of a question, but I'll do my best to answering it. Listen, the hiring process is quite straightforward. You apply for a position, you interview for it typically, and then you are made an offer of employment. That offer letter or that employment contract. And actually, this is a great opportunity to touch on the following subject, Sam. So I still appreciate you asking the question. Listen, it's always great news to be offered employment, right? It's always good to know that you have been chosen as the person that this company wants to hire, right? And typically, most people will look at an employment contract or look at an offer letter and say, what's the pay? What's the benefits? What's the vacation look like? What position or what title am I going to have, right? And what's the job description? Those are obviously the big ticket items. And that's great. Listen, those things are important. Don't get me wrong. But as a reminder to those of you out there receiving job offers, have a look at the details. Have a look at pages 3 and maybe 4 and maybe even 5 or 6 of that contract or that offer letter. And it is likely the case that there is going to be language in the latter half of that contract that also dictates the terms of your employment in a pretty significant way. For example, an employment contract might have language in it, have a paragraph in it that allows the company to temporarily lay you off. And that's often not appropriate for lots of positions, right? If you're a construction worker, maybe, or a seasonal employee, sure, that language is appropriate. If you're in IT or tech, or if you're in sales, a temporary layoff provision in an employment contract doesn't make a heck of a lot of sense. You probably don't want it in there. There might also be language about termination or severance. Have a very close look at that language. It will dictate, if you're let go and if things don't work out, what the employer might owe you or not as severance. Those paragraphs are quite important if we're talking about a severance claim if you're ever let go. In other words, look at the details of the contract. And if you're not sure what something means, if you're not sure that this contract is right for you, we do employment contract reviews all the time. Make sure you speak with an employment lawyer before you sign a contract, especially if you get a funny feeling that something's not right about it. Sam, thanks for your question. All right, moving on here in the last few minutes, we'll rapid fire a couple of these Q&As. Kathy asks, Kathy, thank you for your question. Can you talk about frustration of contract for someone who's on disability? What reason would an employer try to let you go due to this reason? It's actually quite straightforward, Kathy, and it's a great question, by the way. This doesn't happen often, but it does happen. If you are employed with the company and you are medically unable to work, and if your doctor's opinion is that the likelihood of you ever returning back to work again is not high at all. In other words, if it is highly likely that you are permanently disabled and you will never be able to work again, your employer is allowed to consider your employment at an end. That is what we call frustration of contract. In other words, it's not the company necessarily letting you go, and it's not you resigning from your employment, but because of your situation, because of your medical condition, essentially, right? If it's the case, and this is the most important piece of it, of course, if it's the case that you'll never be able to return back to work again, your employer does have the right to let you go. You would be owed severance in the circumstances, Kathy, at least in Ontario, you would, but your severance entitlements would be limited. It wouldn't be your typical severance entitlements based on your age, position, and years of service. Kathy, these are tricky issues. An employer cannot pull the trigger too quickly and let you go for frustration of contract too soon. Right? The timing has to be right, and the evidence has to be there by your doctor that you're permanently disabled. If you're concerned about any of this in your particular situation, again, contact us. Visit the website, give us a call, send us an email at help@employmentlawyer.ca. And I promise you will get the correct advice in the circumstances. All right, DF asks, how long after you are told your promised salary increase for increased responsibility has been retracted, do you have to take action and still qualify for constructive dismissal? Interesting question, DF. So this is a situation where effectively you've been promised a raise or a promotion, perhaps, and then that promotion has been taken away from you. And the question DF is asking, and it's a good one, is how long do you have to act? And what that's implying is, well, listen, if you wait too long, right? So if you're offered a raise and then it's retracted, and I don't know, 6 months go by. Well, listen, in that kind of situation, it's going to be, and they go by in silence. Let's say you don't say anything about it, right? And you just kind of grin and bear it and keep working. Listen, after 6 months, it is possible that an employer says, well, listen, we thought you accepted it. Why are you making an issue of it 6 months later, right? That might not be a reasonable response time in the circumstances. But DF, I do have to say, listen, there's no set time. I cannot tell you that it's 2 weeks or a month or 2 months or 3 months or 6 months. As I mentioned in that example, it really is very context specific. It does matter if you've already expressed concern about these things, right? So if the offer has been withdrawn and you've taken issue with it and you put that in writing, you might have a little more time than you might think, right? But if it's been silent for many months, you might be out of time. I hate to say it. So the devil's always in the details. Right? Make sure you're getting advice in this situation. I wouldn't want to tell you one way or the other that you're out of time without knowing the detailed ins and outs of your situation exactly and reviewing any documents or emails that have been exchanged or messages that have been exchanged. So listen, time is of the essence, it sounds like, in your situation. Do make sure you reach out and and get those questions answered. We are up against the clock, guys, but if you'll allow me, we'll go a couple of minutes over time because I do want to get to the remainder of the questions, at least to those of you that are not asking follow-up questions here. John asks, what do you need to prove you work in a toxic work environment? John, ideally, you have evidence in writing or some sort of documented evidence. So these, again, could be emails or text messages. It is always the case that documented evidence is going to be worth more, right, than verbal evidence, because oftentimes a verbal situation becomes a he said situation, or he said she said situation, where one person is alleging one thing and the other person is responding the other. I will say this, John, very quickly. If you're dealing with a toxic work environment, step number one, either contact your HR about it or contact your manager about it and put that down in writing. If you put your concerns in writing to your employer about bullying or harassment or a toxic work environment, they have an obligation to investigate. And that's the documentary record that you need to get started, right? The employer will then need to investigate and resolve the issue. If they refuse to investigate or if they refuse to resolve the issue, that's when you give us a call, right? And we could talk about evidence in that case. All right. Last two questions for today. And then those of you that I might not have gotten to or didn't get a chance to post a question, we will have a live stream next week, guys, so don't worry about it. Very quickly, Peter asks, I was suspended without pay and I'm intending to request payment for the 2 days I was suspended for. In doing this, found out that we do not have a workplace contract. Is this legal? Peter, great question. It is not illegal to not have a workplace contract. Actually, if you're a non-unionized employee, Peter, and again, particularly if you're in Ontario, and that is the jurisdiction that I practice in, so my advice is geared to this province, right? It's actually okay not to have a contract at work. Actually, by not having a contract with your employer, you're actually better protected than those employees who might have a contract, but that contract limits their rights or limits the options that they might have in particular areas. So, Peter, I'm actually not worried about you not having a contract. That doesn't faze me at all. Again, particularly if you're a non-unionized employee in Ontario. The suspension, listen, I'd obviously love to know the reason for the suspension. If they've suspended you for disciplinary reasons, right? We need to know what happened there and what the degree, if any, of culpability is. I have no problems with you requesting those 2 days be paid if you feel the situation is unfair, right? And if the situation can't be resolved, Peter, again, don't be shy to contact us. Give us a call. I'd be happy to have a chat with you about it. Last question for the day, folks. Bronto on YouTube asks, what can you do if your employer has made a number of changes over several months? Individually, the changes aren't much, but collectively, it's a big change. Bronto, excellent question. I think the quick answer to that question is, listen, several changes combined together over the course of a few months can absolutely lead to a big change and a constructive dismissal. Ideally, there is a record there to a degree, Bronto, of you taking issue with these changes or taking exception to these changes, right? If it's the case that you've accepted all of these changes along the way, it becomes very difficult to renege on that acceptance and now take issue with it. So again, and I've said this a few times today, for those of you tuning in, the circumstances, very particular circumstances that you're dealing with, and the interactions that you're having with your employer while this is going on are going to matter a lot. Bronto, I would say that several changes made over the course of a few months can absolutely be considered a significant change and therefore a constructive dismissal, right? But we need to look at what happened during those months and what the interactions were at the very, very least. And I would say this kind of situation, Bronto, is the exact kind of case that warrants a conversation. So again, do not be shy to reach out and give us a call. Thank you all so much for tuning in. Thank you all so much for going overtime here a little today. You all asked some excellent questions. I hope I was helpful, even if just a little bit. We will have another live stream next week. Have a great weekend, everybody. Have a good rest of your day. Take care and so long.